Hello, everyone, and welcome to Ace Your Assessment podcast series. We've got a very important person with us today. I'm going to introduce him in a minute. So, today we're going to approach the topic of how to approach problem questions in law exams. So, this is Eleanor, and today with me, I've got the head of law school, you guys, Alan East. He joined academia in 2010 after a successful career in legal practice as a defense duty solicitor and senior crown court prosecutor. He's developed a successful career as a disruptive influence in teaching, learning, and assessment, culminating in advanced higher education awarding him the coveted National Teaching Fellowship for the work he has done supporting students and providing innovative and engaging teaching. Now, Alan's area of teaching and learning is problem-based learning. My God, we couldn't have found a better person for this. And you've embedded this pedagogy in all of your teaching because, as a former solicitor, you believe that it is vital for students to learn how to apply legal knowledge to factual situations. Now, a very interesting thing for you that I can share with the students is, well, actually, two things. I'll be cheeky there. You've created the International Law Clinics at Coventry University, and also you were the chair of the Education and Training Committee at the Law Society of England and Wales. Welcome, Alan East.
Hello there. Thank you for having me on this wonderful series.
Thank you. Thank you very much for coming, Alan. Well, just to start us off now, quick question to you. Why is it important, to know for the students how to approach problem questions in law exams?
So the law affects us in a variety of ways. And when you go into professional practice, you'll be dealing with a lot of problem scenarios. So it's really important to have an assessment form that will give you the skills to do that. So you'll have loads of different types of assessments, but problem questions sometimes cause students lots of problems. Probably because students are familiar with answering essay questions, but actually answering problem questions is very, very different. So I thought it's really important to talk about it so that you know how to prepare for a problem question and then how to answer them, because there's a real skill to it, and it will then allow you in the future to deal with problem scenarios if you go into legal practice or any sort of professional practice, whether it's legal or not.
Hmm. Well, I think students are going to be all over this particular topic. I do know that you've got some slides for us today as
Yes.
well, so do load those up. Of course, we're going to expect a very entertaining set of slides. I really do like your presentation slides, so
Thank you.
I'm looking forward to those. Just
Okay, brilliant.
just upload them, and we'll
Okay,
start whenever you're ready.
okay. Just let me know when you can see those on the screen.
Yes, of course. I can see them now, so
Fantastic.
everyone
Well,
will see. Yes.
excellent. So that this really is about how to approach or answer problem questions.
Mm,
So just before we start, there's going to be a sort of introduction about problem questions, and then we'll be looking at what is a problem question before talking about preparation is vital before you actually answer the problem questions. So you have to take those in two separate stages. Preparation is the key, and then I'll
mm,
talk about some do's and some don'ts before finishing the presentation.
super.
Okay. So, as I said, the law affects us all in different ways. And as law students, I'm sure many of you will want to go into the legal profession where you'll be dealing with lots of factual situations and lots of problems. Clients will cause you many, many problems with their variety of issues, and it's up to you to solve them. But even if you don't go into the legal profession, you'll be in professional practice somewhere dealing with issues and problems that you'll need to solve. So here at Leicester de Montfort Law School, we are providing a world-class education, and our students will be able to tackle many different types of assessments. And one of those is the problem questions. So it's really important to understand how to go about answering them. So this, in essence, is what practicing lawyers do on a regular basis, as I have done in my career as a defence duty solicitor and then at the Crown Prosecution Service. So whether you become a solicitor, barrister, or legal executive, or working in the legal profession, the skill of dealing with problems is essential. So you have a client, if you're in legal practice, you have to advise that client relating to many different legal issues they will have. They will want you to give them clear advice. So you will have to look at their case, understand it, and then advise the client on it. So a legal issue will differ dependent on the facts of any particular case. And this is practice for the real world of law. But as I said, even if our students do not enter the legal profession, dealing with problem scenarios is essential in all professions, in business, industry. So the skill of answering a problem question is universal. And I want you all to tackle them successfully and get the best marks possible. So hopefully this podcast will help you.
Yay, I'm already pumped to hear all of it.
Okay. So what is a problem question? Well, I want you to listen very carefully to what I am about to say, because this is essential. It is not, let me repeat that, it is not an essay. Problems for a lot of students that I've found are marking problem questions is students tend to approach them as if they're essays, and you're going to get yourself into some difficulty if you do that. So you need to think it's not an essay. And I've marked some problem questions very recently where students have actually said within it, in this essay, I will do this. It's not an essay. So let me repeat that one more time, Eleanor. It is not an essay, because it's a completely different approach to writing and preparing for an essay. Okay, yes. Problem questions are where you apply your knowledge of the law. We're looking to assess your knowledge of the law and applying that, and that's the key, application to real life factual situations. So that could easily be, and it can be many different types of cases, but a dispute between two parties, for example. If you're doing family law, it could be a divorce scenario, or a claim as to who will look after the child. In tort, it could be in relation to negligence. In criminal law, it could well be whether the person is actually guilty or not of a criminal offence. So it will generally be a dispute. It'll be where something cannot be agreed. And that's where solicitors, barristers come in and take things to court, because it's where the court will draw conclusions and where the court will give a judgment, where people don't agree. Where people agree, there's no issues. So if we compare that to an essay, that's about analysing legal principles. So this will, in answering an essay question, require you to consider the opinions of legal academics. Considering what legal academics say, that could be in a journal article or what a judgment in a court says. These are often in relation to abstract principles of theory of the law. You don't give your own opinions in an essay question, but you critically analyse the opinions of others, notable academics, the judgments in cases. But with a problem question, it's very different. We will be asking you to advise someone on their legal rights. So we're actually asking you for your opinion as to how this case will develop. What do you think? Give your advice on whether or not somebody is guilty of a criminal offence, and that is the difference. So you must approach them very differently. So have I made that perfectly clear?
Definitely. Certainly.
If you take one thing from this podcast, it's that Alan says, as head of law, you must treat a problem question differently to an essay question.
And it's all about applicability, application.
That's exactly
what about
right.
Preparing to answer a question? Because there's a lot that goes on beforehand, doesn't it?
Well, that's it. You can't just turn up and start writing the answer. It's the same with an essay. So there is a similarity with an essay, okay, and a problem question is that you do need to prepare Okay, but that's where the similarities actually end. So looking at preparing for a problem question, you must apply a different mindset to preparing for an essay question. Okay, with a problem question, you will be presented with a wide range of facts, usually a story. Okay, whereas in an essay question, it will be a fairly short question. So you will be presented with a lot of information in problem questions, and that can be quite off-putting for students. Don't let it be. Okay, if you follow the guidance on here, it will make it easier to prepare. So you need to read the facts very carefully because the facts contain clues. Okay, it's like Cluedo. Okay,
Yeah,
the facts
exactly.
contain the clues. When the police go and investigate an alleged criminal offence, they're looking for clues in the facts, the evidence. Okay, so you've got to read it very carefully. So my advice is very slowly read it and underline or use a highlighter and highlight any relevant words or sentences, and they will really jump out at you when we're actually writing a problem question for students. You know, we want to help you as much as possible, so those clues will be very apparent. So make sure you take some notes and make sure you reread the facts a number of times because you've got to fully understand them.
Alan, on this point, it's very interesting that you're saying about highlighters and everything. I sometimes, we've got land law, we've got equity and trust. Very often, we'll have problem questions on these, and you'll have characters. X, Y, and Z do whatever it is that the problem question is, and that sometimes is very confusing. So I tell students to either use different color codes for
Yes.
different characters, then different color code the problem question depending on which person it is involved in the
Yes.
specific issue. So you make sure that you also create in a way a list, and it's a box ticking approach to make sure that you've dealt with all of them. Of course, we've got the colorblind people as well that might have an issue with that, and I usually say put a different font, so use it
Yes, sure.
digitally, and you use a different font for each name and different font for each issue that comes up in the problem question. And that's the beauty of rereading your problem question to make sure that when you
Absolutely.
question yourself, you understand it really well. Thank you.
No,
That's
that's absolutely true, because what you're alluding to there is actually problem questions are quite complex factual situations that may have more
mm,
than one or two characters, and there may be different factual issues that you'll need to grapple with as well as different legal issues. So that's why it's really
mm,
important to sort of break down the story a little bit and take some time with it. So do not jump straight to applying the law. When you're reading the problem question, you might think, oh, actually, this could be self-defense, and make a note of it. But don't go straight into looking at self-defense. You might see if it's a family case, oh, this could be behavior, so make a note of it. So don't go straight to applying the law first. You want to make sure you've got the relevant information, because what is relevant is important. Okay, if there's irrelevance in there, then you're going to get it wrong. You need to be sure
mm.
that what you're going to talk about is relevant. Okay, and then do not assume that because the facts of a problem resemble a well-known case, the problem must be resolved the way as that case did. Very often the author of the problem question deliberately tweaks the facts so that it is different from the leading case. So some academics might use the facts of a case as the basis for their problem question, but will change things around a little bit to be able to tease out your understanding. So what is then needed is an analysis of the law discussed in this particular problem question.
Mm.
Okay, so do not assume either that a leading case that factually resembles the problem is necessarily relevant to the problem at all. Different legal issues can arise on the same facts. Okay, so it's really important that you understand what those facts are. And if you've revised and if you've done the reading and attended, and let me say this, attended all sessions, because engagement and attendance is where you do well. If you've been to all the classes, because let me assure you that the team will be helping you by putting clues into their seminars and lectures. If you've attended everything, you'll have an understanding and you'll be able to see those clues. So let me remind you of one key principle. This is not an essay.
That's very good. Well, you said earlier at the beginning that you're going to tell us about the IRAC method as well, because obviously there is, I like when I talk to students and I explain to them, I know it's this big piece of work, but if you take a mathematical approach, sometimes that helps. When you're organizing your number of words, you might have 1,000, 2,000 words. Put some aside for the introduction, put some aside for
Yeah,
the conclusion. Then if you have 3 characters or you've got 3 issues or whatever the case may be, split those into, the remainder of the number of words into those issues.
that's
Um,
right.
there is a way of going about things in writing, in legal writing, academic writing, to make things mathematical in the sense that you make sure that you've put those things there or you've dealt with them in that way. And the IRAC method is a little bit like that, isn't it?
Yeah, it's just a guide. It's really just to sort of to make you realize that this is a problem question rather than an essay question. So the key thing in the back of your mind, you just need to consider, what does IRAP mean? First of all, the I stands for issue. There will be issues because it's a dispute. If it wasn't a dispute, there wouldn't be anything to talk about. So you're looking for issues. They are factual or legal issues. The R stands for rule, which is essentially the law. That will either be usually statute based, but it could well be dealing with the interpretation of statute through some case law. The A is for application, which is the key thing in order to get the highest marks. It's all very well being able to explain what the law is. That's all well and good, fantastic. But
Yeah.
what you need to do is apply that to the facts of the case, which then allows you to draw C for conclusion. Okay. So just have that in the back of your mind. It's the principles behind a problem question. That's it. Identify the issue, then be able to establish what the law is, the rules, and then the application of that. So you can do what I've said you need to do with the problem question, which is having an opinion, draw that conclusion.
Hmm.
Okay, so really what I want to talk to you in some detail is about structuring. Um, Structuring the answer. How do you go about it?
Super.
Okay,
Yeah, tell us about it.
no, okay. Because it's a legal problem with a legal answer, there is usually a pretty clear structure that can be followed when answering problem questions. So as with all writing, you should start carefully planning what you're going to say. And so an introduction and a conclusion are needed. Okay, but they are more easily managed in problem questions than with essay questions. So the introduction really is talking about, this is a legal problem where we have to establish, and whatever that particular problem is, that could be self-defense, it could be hearsay evidence, it could be a divorce situation. And the conclusion will be setting out usually what your advice is. The advice in this case is that the person is guilty of the offence of murder because. Okay, with the introduction, as this is a real life situation and you're being asked to advise your client, the first question to address is, what does my client want to get out of this? Therefore, summarizing this succinctly at the beginning of your answer, maybe alongside a short statement about the contentious area of the law, always operates as a good, clear introduction. Everything else that goes into your problem question will come after this stage and before your conclusion, which is usually your advice. So after that, it's the main bulk of your answer, which is where you demonstrate your understanding and knowledge of the law you've learned, and then your ability to apply that to a set of given facts, following the guidelines that I'm just going to go through, which will help you construct a very good answer. So the first thing is identifying the issues. I've said before that they could either be legal or factual. So when you first see them, problem questions do look very daunting. there will be a lot of information and you may not know where to start. An essay, on the other hand, may only be a 2-line question, and it could be even shorter. So your problem question could well be pages long. The one I've just written for the law of evidence in the final year of the undergraduate degree was 3 or 4 pages long, relating to quite a
Oh,
complex criminal
goodness.
scenario with a number of different legal issues. Okay, so the first step, obviously, with IRAC is establishing the issue. So they'll be both factual and legal. So look out for those. When reading the problem question, the first task is to spot those issues. And as I've said, there will be clues.
Mm.
Okay, so
You guys for evidence, especially listen to this. There are clues.
there are, yeah, no, there absolutely are clues. So go through it carefully, pausing after each sentence or paragraph, and really think about what's happening in this particular case. So we've talked about underlining, highlighting, picking out key phrases, for example, that have put in there for a reason. Okay, and factual issues are facts that you're obviously being told for a reason, rather than just those that you have to be told in order to make the scenario make sense. Okay, so look at what the facts are telling you and ask why you would need to be told this. So, for example, somebody gets assaulted. What's happening there? There could well be self-defense there, depending on how those facts are actually written. And that would be a key issue in a criminal case, because that's a defense. Many of the facts in a problem question may seem unrealistic, but remember, the writer of the question has to design it to raise legal issues that you can analyze. So some of these situations may be beyond belief. Look out for red herring facts that are either not relevant or inserted to lead you off the right track. So this is about, so we're testing not just your understanding of the law, but being able to identify what's relevant and what is not relevant. That's often key in any sort of legal case. These are a valid technique designed to see if you know what you're talking about and what is and is not relevant. We are, remember, assessing your understanding in quite a complex way. So what you shouldn't do is make up any facts that are not there. You cannot make assumptions and can only discuss the facts as they are given. I've seen many students just go off on a tangent, making up things, and that just isn't relevant.
Yeah, we're not looking for that, you guys.
No. So remember, you've got to identify those issues, those disputes, those factual disputes, but also those legal disputes, because that's what we need to answer. We need to get to grips with those so we can give that conclusion and that advice. So then, of course, you've got to identify the relevant law. So you will have all, I'm sure, have attended all your sessions, because successful students are students that attend and engage with all of their sessions. So our brilliant staff can teach you and give you their wisdom and support you. So if you've attended everything, you've done all your reading, then you should be able to identify the relevant law, because when courses, programs, modules are designed, it's designed to help you get to and do well in your assessment. So once you've identified the issues that you're going to consider, you then need to work out what is the law to be applied. Remember that any of the factual issues will be signposts to legal issues, and therefore possibly also signposts to point you in the right direction of the actual law. So the law will primarily be statutes, particularly in, say, the law of evidence. It's all very much statute based in the first instance. So read that statute. You have access to Lexis Library and Westlaw. They keep that statute up to date. Download it, read it. You must read through it, because in a moment, what I'm going to do is tell you that when you are then applying the law, you need to read the detail of that, because the drafters, the law commissions, the drafters have spent a lot of time working out what the individual words mean in that law. There will be cases to analyze as well. Remember to read those judgments. Take the time to do so. You have access to pretty much most of the cases and statutes through the library resources that we provide for you. Okay, so
They would
you've
have
got
had
to,
a lot in class as well in the
oh yeah,
seminars because we
absolutely.
go through these cases, we talk about them, we actually apply them in examples of problem questions in class. So yes, you get a lot of preparation before you get to do your research and get stuck into
Ex-
your
ex-
preparation for the
ex-
assessment.
exactly. So the detail is important here. Everything is in the detail. So if you're going to get a higher mark, you're going to know the detail of the law. So when you're about to apply the law, you mustn't just say everything about it. You need to pick out the relevant bits of that law that relate to the legal and factual issues.
Mm,
So that's why it's really important to read through the statute carefully and apply just the relevant parts of that law to this particular instance or that particular case. And you can only do that if you've put the work in, gone to
mm,
every session, understood what's being said, and then read it yourself afterwards. Students that do that will definitely get the higher marks. So really important to identify the relevant law. The rule in the IRAC that we've talked about earlier. Issue for I for issue, R for rule. And then it comes to what's probably the most important part. This is where the most marks come from, which is the
mm,
application. So some students, the weakest students, unfortunately, will just tell us what the law says, but then not be able to apply it. Okay. It's great to have an understanding of the law, to know what it means, but you need to be able to identify what's relevant to the particular factual situation. This is the main part of the problem question, and I think where most of the marks are actually lost. Okay, so
mm,
many students sometimes do not grasp what it means to apply the law. That's why I thought it was important to run this particular podcast. So many students will simply stop at stating what the law is relevant to the facts and the issues at hand without going on to do something with it. So being able to describe the law is
mm,
fine, but it isn't enough. You've got to be able to apply it. So you're doing something with the law. You're using the law to answer the question you've got, to give the advice to the client.
mm.
Okay, so if you have a client that wants to know what money they're going to get when they're divorced, then you need to look very carefully at the Section 25 factors in the relevant statute and be able to
Mm.
pick out which ones are relevant to what your client's told you, because that's your case. Okay.
Oh wow.
So if you can apply the law to the problem, you demonstrate a higher level of understanding than simply being able to identify the issues and describe the law. So description is not enough. Okay. So I think that's a really, really important part. So actually what you do with the law, first of all, you need to understand the law, particularly statute, as building blocks. When you look and read through a statute, it's set out in blocks, or I sometimes call it elements. So with a criminal law, for example, when a criminal offence is written, obviously your knowledge of criminal law is that you have an actus reus and a mens rea,
Mm,
but within that actus reus, you may find there are different acts, and each of those acts have to be present for the law, for that offence to be there together with the mens rea. So you
mm,
need to kind of break down what the law is saying with the law of evidence, for example, which is very statute based. There are lots of gateways of admissibility of evidence, for example, hearsay, for example, bad character. But students miss out on the mark, so they don't go into the finer detail of the statute and break it down and apply each part to the relevant facts. And it's quite frustrating because I can see students have an understanding, but when they say to me, well, why didn't I get a first? Well, because you didn't go
yes.
into that level of detail. But I understood the law. I said, but you didn't demonstrate it to me in your answer.
Yes, yes.
Um,
I think lists will probably help here the student to
absolutely.
make sure that when you're breaking down the law, you're then looking at all of the relevant points in your problem question and then you're ticking them as you go to make sure that you're not only
Yep.
identifying the issue but also applying it. So each element of it. So we
And
don't want you to apply the whole of it in a
that's
general
it.
sense. We want you to apply every single bit to it, and every relevant issue needs to be dealt with
And
in detail as
And that's
well.
right. So when I've just finished marking scripts for the Law of Evidence, which is a final year module, so it's quite
Mm,
complicated, and it's a very complex criminal case. And for example, the law of hearsay is extremely complicated. And what students sometimes do is they say, this is hearsay evidence because it's a statement that is not in court. And I just think,
Mm,
well, that's not what the law says. Tell me what the law says. First of all, the law is section 114 of the Criminal Justice Act 2003, and it states it's one, the first element, a statement. The second element is not made in oral proceedings, and the third element, it's evidence of a matter stated. So let's break that down. Why is it a statement? Well, you then need to go to section 115 that defines statement and then
mm,
apply that. And then apply that to the facts. So the statement is actually an oral statement made by the witness at the side of the road where a car incident has happened, made to another person. So that level of detail, not, and then, okay, so it's ticked off, it's a statement. It's still not hearsay evidence until it is not made in oral proceedings. Well, this particular witness, unfortunately, cannot make it to the court because they've got a job overseas and aren't able to come to give oral testimony. That means that it will not be made in oral proceedings. It's still not hearsay yet until you apply the third part, evidence of a matter stated, which is defined under section 115 to cause
mm,
another to believe it. So explain what that means and apply it to the facts. Then you can conclude that is hearsay evidence. That's just the first part. So now we know it's
mm,
hearsay evidence. We know it's not generally admissible until it's applied through the relevant Criminal Justice Act provisions. So now you need to go through which provisions are relevant on the facts of the case. Fine. Section 116, the witness is unable to come because they're overseas. So take me through what that says in detail.
mm.
That's where you're going to get your first class answer, not simply saying, oh, this is obviously hearsay because it's a statement, the person's not coming to court and they're not being able to court because they're at work. That's hearsay and that's why it's admissible. That's not enough.
Yes, you've missed all of the analysis. You've missed the critical analysis, really, because this is what we're after. And then obviously the application, because just because you can see the answer, you can see the correct result, as it were, in your head, it doesn't mean that you've actually explained it in your words, in your assessment, to
Exactly.
get for us, to enable us actually to give you the points
Abs
because we want to give you the points. We just can't give you the points because the
no, no, that's
information
right.
is not there. Not because we
Exactly.
probably think, oh my God, I know this student, but most of the time you're going to look back at the paper, don't you? Because you're marking anonymously anyway, and then you're thinking, how did they not get it? Because I know that they're
Well,
bright.
this is
They're
it.
you just sometimes we even overlook things because we even now you're going to talk about proofreading, I know in a minute, but sometimes our brain, our eyes look at your own paper and read whatever your mind
Yeah,
wants to read rather
that's
than what you think, what is actually on the paper. So whatever your mind thinks it should be there. So yeah, be very careful because your mind is very, very tricky.
absolutely, absolutely. So I hope what you're all beginning to understand now is the devil's in the detail.
Yeah.
Okay, and you need to understand the law in detail and apply it bit by bit, step by step, building blocks, and give me that level of detail. You need to explain to me in your written assessment why you need to get a first and how much you understand the law, because I can't draw a conclusion from reading it,
Mm,
because I'm like, well, I can see they understand it, but they're not explaining it to me. That's your opportunity to explain it. So that's the main part. And then of course you've got the conclusion. So you've got to provide a conclusion. Usually it will ask you to give legal advice. So you're actually giving your own opinion, which you wouldn't do in an essay. You're saying this person is guilty of the offence because of what I've explained in the main part, or this person can get this outcome from their family law divorce, so on and so
mm,
forth. So make sure that you give that conclusion.
super.
So I think really to sort of finalize, hopefully I've made it very clear that it's not an essay and that there's a particular approach to how to write a problem answer to a problem question. So here's some do's and some don'ts, some tips. Okay. So do not restate the facts given in the question. Lots of students seem to start off with volumes of telling me what the facts are. Well, I know what the facts are. I've written it. You don't need to tell me again what the facts are. Only tell me what the facts are if you're going to make a point about the law, and you need to do that as part of that explanation, and fairly briefly and succinctly. That's really important. Don't just restate the facts. Okay. So do make sure you clearly state what the relevant law is and why it is relevant. Go through the detail of the wording in the statute. That's really important. Break it down. So one thing you mustn't do, and this really gets me passionate about it, is do not make up your own words. The drafters of the law have spent a lot of time, they're very experienced lawyers, coming up with particular words. Do not paraphrase it. If you make sure you state what the law says. So many students on the hearsay point are saying hearsay is proving the truth of the contents. Now that's the common law, which has been superseded by the statute, is now a matter stated, causing someone to believe it. So you must use the correct words. That tells me you've read the statute. So write what it says in the statute, because often those words have been considered in some detail by the drafters. Okay, don't stop at merely stating what the relevant law is. So that goes back to the point about don't just tell me what the facts are, and don't just you need to say what the law is to be able to explain why it applies, but don't just say what the law is and don't apply. You must apply the law. That's the key thing. Okay, so you must use cases and or statutes as authority. Obviously, that goes without saying. You must show us you understand the law and actually say why it applies to the facts of the case. And do apply these directly to the facts and issues at hand. So that's where you can mention the facts but only very briefly, because you've got to explain to me why it applies. Okay.
Yes.
And do make sure you draw conclusions from your application of the law. Okay. And don't forget there may be counter arguments to your contentions, and that you should bear these in mind. That's that critical analysis point, looking at, well, it's our client's case, this, but actually the other side, because there's an issue, there's a dispute, will say this. You've got to be able to weigh those up when you come to your conclusion. Okay. And the biggest don't is don't think this is an essay. It is not.
I knew you were going to say that. So will that be your last thing, Alan?
Well, that's it.
I wanted to ask you, could you say one last thing to the students? But I think that is just the message throughout.
I will say it one last time. It is not an essay.
Oh, this is brilliant. Thank you very much. It is true. Very many students get it all wrong because of that, and they treat it as an essay, and they just regurgitate the law, and so it gets to the point where everyone says too descriptive, too descriptive, too descriptive. Right. So I think, the information, the steps, the detail that you provided to students today will be extremely helpful.
I hope so.
Across board. You can apply this no matter the year, master's student, doesn't matter, whatever the case may be, whatever your level. If you're doing law, this is a very, very good approach.
This is good guidance, yeah.
Yes, brilliant guidance, brilliant guidance. Well, Alan, thank you so much for being here today.
My pleasure.
You guys, you're very lucky to have Alan talking about the thing that is within his expertise, and obviously that came across through your presentation today, through the slides and the level of detail that you provided. So thank you, Alan, for coming, and we'll see you guys in our next podcast. Take care.